Today we're going to be talking about hearsay. Now, hearsay trips a lot of law students up, and rightfully so. Hearsay and all of exceptions can be very confusing, but before we even get that far, it's important that we have a fundamental understanding of what exactly is hearsay. So the hearsay definition is an out-of-court statement offered in court to prove the truth of the matter asserted within. What does that mean? Well, we're going to ask ourselves four main questions when it comes to evaluating that. Who, where, when, and what are four things that I want you to keep in mind anytime you come across a hearsay evaluation. We have to first fundamentally break down, is this hearsay, before we can even get to the exceptions. Before we do that, also, I want you to draw a box. Imagine that box is your courtroom, and everything that we evaluate is going to be done from the purview or the perspective of that courtroom. Anything outside of that courtroom, we don't care about. We care about what's going on in court at this time, at this trial. Now, before we dive into our who, where, when, what, we also want to remember statement, right? Statements are not always oral. It could be oral, written, some kind of other communication like body language, nonverbal, even a head nod could be considered a statement. The next is who. Who's making that statement? Is that person a witness today in court in this trial? The reason why that's important takes us back to the reason why hearsay is so important to begin with. You have to give both sides an opportunity to cross-examine the witness. If that person is not a witness today in court, there's a good chance, your red flag should be up, there's a good chance that what they're saying is probably going to be considered hearsay, but for some of the exceptions. So you want to look at who's saying it, and are they a witness in trial in court? Where are they when they make this statement? Are they in court at this moment, at this trial? If not, there's a good chance what they could say could be considered hearsay again. And we might want to put that on the back burner for when we get to our exceptions, but these are just some preliminary evaluate questions that we want to ask ourselves. Where are they making this statement? Are they at court at this trial in this very moment making this statement? And then what are they saying? Are they saying this to prove the truth of the matter asserted within? And what that essentially means is the statement trying to come in to prove the very point of why we're here? Let me give you an example. I was actually in court yesterday, and a pro se defendant was there on a default for making credit card payments. And she was telling the judge, she said, "Judge, I'm not in default. I made payments September, October, November, December, and January." And the judge says, "Okay, show me your payment slips." And she says to him, he says, "I don't see any payment slips for December." And she says, "Well, Judge, I called and the representative said that their payment systems were down." And so he said, I cannot consider that because that's hearsay. And she didn't understand, but the judge was absolutely 100% correct, and here's why. Who was making the statement? Well, she was saying that the call center representative made the statement. That person was not in court at that time. They were not a witness at this hearing. Nobody from the company representative was. She was saying it on their behalf. So she did not have a witness at that trial. So not a witness. Where were they when they made that statement? They were either at home or in the office doing their job. They were not in court at that trial during that testimony. When did they make that statement? When they were doing their job back in December when she paid. They were not in court, not in trial at this time when they said the payment systems were down. And what were they saying? Was it presented to prove the truth of the matter asserted? Absolutely. The whole reason why she was there was to prove that she had made credit card payments on time. And so her saying that the call center representative gave a reason for why she couldn't make the timely payments, well, that's the reason why we're there. So in its totality, this lady was trying to admit hearsay into evidence, and rightfully so, the judge told her not happening. If the person is not a witness in trial, making the statement before the court, during court, at this time, at this trial, at this moment, and saying it for the truth of the matter asserted within, then it is hearsay. And it is not allowed in court. Now, if the lady in court has said, "Judge, the reason why you don't see a December ledger payment is because I had to mail my payments in because the call center lady told me that the payment systems were down, and so I mailed in a check in here. I I have a cashed in receipt from my bank saying that this check was cashed by that company, then her saying that the call center lady telling her the systems were down is not necessarily hearsay anymore, because she's not using it to prove the truth of the matter asserted. She's already got her proof, right? She's got the receipt saying that they received payment in some form or fashion. She's just explaining why payment was tendered one way versus another, and that would not be considered hearsay. Again, hearsay is an out-of-court statement offered in court to prove the truth of the matter asserted. And so you want to look at who, where, when, and what when it comes to evaluating whether a statement is hearsay. In our next video, we're going to talk about the hearsay exceptions.